As Benjamin Franklin once said, nothing in life is certain except death and taxes. Yet many of us, I think, are wholly unprepared for the inevitable. We have a lot of questions. How can we pass along our estate and protect our assets? Do we need a trust? Do we need life insurance? What should we look for in a trustee? What should we look for in a guardian for our children? What if we can no longer make decisions for ourselves? And how can we pass along our assets without tax liability? There are so many questions surrounding estate planning. And today we are so fortunate to have two of the most well-respected experts in estate planning on the podcast, David Posner and Jillian Merns of Wilkie Farr and Gallagher. David is a partner and chair of Wilkie's Private Wealth Group, and Jillian Merns is also a partner in Wilkie Farr's Private Wealth Group. Their practice focuses on counseling high net worth individuals and family offices on a wide range of legal matters, including estate planning and estate and trust administration. They have extensive experience in the development and execution of sophisticated estate plans and wealth preservation techniques, including the preparation of complex wills, trusts, and related instruments. They regularly advise clients on estate gift and generation, skipping transfer tax matters. They have experience relating to charitable giving, including the use of charitable trusts and private foundations. They also work with many single and multifamily offices to provide comprehensive solutions to the complex issues facing today's wealthiest families. In today's episode, Jillian and David provide an incredible overview of the estate planning process, what we should all be thinking about, what documents and tools that we need, what are the best practices and advice out there for how we should be structuring our estate, what issues we should be considering, do's and don'ts for estate planning. It was really an incredible privilege and honor to have such superstars in this field on the podcast. I learned a tremendous amount from them both, and I know that you will too. Jillian and David, thank you so much for coming. It's so wonderful to see you both, and I really appreciate you taking the time. Estate planning, a subject that none of us really want to think about because it means planning for our assets when we're not here, which is not necessarily a popular thing to be thinking about, but it's something that will happen to all of us. And so it's something that we need to be thinking about and planning for. When you both have clients come into your office, sort of the first meeting that you have and are giving them kind of an overview of the process or what they should be thinking about, what does that conversation look like?
Sure. Yeah. So, basically we sort of lay the groundwork on what are the basic documents that everybody should have in place. So we'll walk through those. Those are typically a will, a revocable trust, a healthcare proxy and living will, and a power of attorney. And those are sort of the basic documents. Those are the documents, that you associate with how you would dispose of property, how somebody could make healthcare decisions for you if you were incapacitated. And then we would talk about sort of the transfer tax landscape, both federal and state, because estate planning sort of has two components. It has the dispositive component where you're deciding how to dispose of your assets in a way that'll help your family. And then there's also tax planning. And, we have to deal with both of those.
So when you mentioned your will, you mentioned a revocable trust, a living will, and a healthcare proxy. And just for listeners, living will is, I think, if you're in a condition where you can't make your own,
sure,
you're incapacitated, right? You're giving instructions about
right.
your resuscitation. Is that?
That's right. So that's when those documents kick into effect is, the healthcare proxy. By that document, you're naming somebody to make healthcare decisions for you if you can't make them for yourself because you are, as you said, incapacitated. The living will is a companion document, and it expresses your wishes about how you'd want certain healthcare in certain, horrible circumstances. And so, it's an expression of your wishes to the healthcare agent.
It's funny. My husband had a great aunt who was, at least this is the Heaney family lore, that she was brain dead. His father said, just give her a few more days. Just give her a few more days. And he was sitting in her hospital bed or next to her hospital bed, and she just woke up. But that is what it's for, right? Is for that instance to kind of
right.
make that directive. And then for people who are not as familiar with the terms, a revocable trust.
Mm-hmm. Sure. So it used to be maybe 20 or so years ago that everybody just had a standalone will. And that's, the document you'd commonly associate with what's going to dispose of your assets. Everybody knows what a will is. And then people started doing a standalone, or what's called a pour-over will, and a companion revocable trust. And it became the revocable trust agreement that is the document that disposes of your assets. And the pour-over will, simply at your death, is a brief document, and it directs your executors to pour any assets that you haven't already put in your revocable trust during your lifetime into your revocable trust at your death. And there are a number of reasons why you'd want a structure like this. The primary benefit of a revocable trust, at least if you fund it during your lifetime, is that if you became incapacitated, somebody could step in and manage your assets immediately without having to go to a court and have a guardian appointed. The other primary benefit, I would say, is that upon your death, if you funded your revocable trust agreement during your life, and so there are assets in that trust, whoever is named as the successor trustee to you on that revocable trust can start to manage your assets right away. Whereas if you didn't have this structure and all of your assets were going to pass under your will, you would have to wait until an executor is appointed to administer your estate. So there could be a long period of time in New York County, this could be months and months, where nobody is authorized to give instructions on your investment accounts, can't sell any real property, and you're really sort of paralyzed until the court issues what are called letters testamentary. So this is why we recommend really to all of our clients to have a companion pour-over will and a revocable trust. And there's some other benefits to having the revocable trust.
Now, the revocable trust, that also is subject to tax. Like there's no.
That's right. This is tax neutral. This is, purely about easing the administration of somebody's estate. And there are some lifetime benefits too. Like I mentioned, if you became incapacitated, somebody could start to manage the assets immediately that are in the revocable trust.
And you mentioned that, your executor could start, as you just said, managing your assets right away. So for people who are not familiar with those terms, how would you just briefly define what an executor is?
Yeah, sure. So an executor, and if it's under the revocable trust, it's an administrative trustee. The role is essentially the same. They have the obligation to collect all the assets of the decedent, to understand where the accounts are, to pull out all the paperwork. Then they're going to open estate accounts or a trust account if one's not already opened. They're the ones who are going to hire a trust and estate lawyer to administer the estate from a more day-to-day standpoint. They will be responsible for signing fiduciary income tax returns for the decedent, estate tax returns, ultimately, if the estate is large enough. So, they sort of step into the shoes of the decedent, and they're paid for that service as well.
I want to get to that too,
Sure.
on the payment piece of that. But so people come into your office, you give them this overview, and then Jillian, if you were advising a client, when you talk to them about getting an executor, identifying an executor, what kind of person would you suggest that your client look to?
Sure. So typically on the death of the first spouse, the most common person to designate as executor is the surviving spouse. That typically is going to be the person who's the beneficiary of the assets, who knows what they are. That's the simplest choice. Then you need to designate a successor in the event that you're the second spouse to die. In that case, many people choose siblings or parents if they're young enough. If their children are adults and responsible, you might consider naming a child. Some people name close friends or possibly like an attorney or a trusted advisor of the family. Those are kind of the universe of options. There are corporate trustees that are also available to serve in that role, but at least with our clients, that tends to be a less common option.
And there's a fee, right? David mentioned the fee. And is the fee the same for every state or for every size of an estate?
You can designate a fee in the document itself. If you don't do that, state law has a statute that differs depending on what state you live in, and that will set what the executor is entitled to receive. Many states, such as New York, have kind of a schedule on a percentage basis that goes down as the estate gets larger. In New York, it maxes out at 2% for estates above $5 million.
And if you name someone your executor, right, they don't know, presumably, that they are. They then are like, I don't want this responsibility, and I don't think that, pick a number, $25,000 is enough for all the work that I'm doing. What kind of recourse do they have? And then what would happen?
An executor has to accept the designation. So at the outset, after you die, they could choose to simply not accept. And then whoever you designated as a successor would step in. Alternatively, they could accept the role, and then, after a certain amount of time goes by, they could decide, I don't want to do this anymore, and then they could resign. And then in that case, the successor would come in at that point in time. It is a big role because, as David mentioned, they're responsible for kind of collecting all of the assets, filing all the tax returns, communicating with the beneficiaries, funding any trusts that might need to be set up under the documents. Typically, depending on the size of the estate, it could take a few years after death. And they're also exposed to liability. They're subject to fiduciary duties, and if they don't follow that standard, the beneficiaries of the estate could sue them, and they'd be subject to liability for that.
Okay. The liability for them not, in the view of the beneficiaries, executing.
Yeah, so certainly if they didn't carry out the terms of the documents, that would be a clear breach, but there's a lot of other opportunities for breach. For instance, during the period of the administration of the estate, assets are invested. And if they are not properly administered, if the assets decline in value, the beneficiaries might object. Now, there's different provisions you can include in the documents themselves to kind of alter the liability standard for the trustee and executor. Sometimes people do that. But the default is pretty stringent, and they're subject to a high fiduciary duty to them.
And so do you recommend to clients that they have, let's say executor one doesn't accept or resigns, that they have some sort of succession plan or a couple other people in line? Or, and I'm assuming each state has a law that who would be designated next if there was no executor assigned?
Yeah, so typically we would have definitely at least one successor named. Oftentimes people name a few people in a list of succession. If there's nobody who's able to serve, the court has to appoint someone. I mean, presumably the family would kind of have to get together and figure out who they'd like to kind of put forward as an option.
Okay, so David, you said you come in, you tell everybody sort of the overview of the 4 or 5 things that they need. And part of that conversation includes you discussing taxes and what the tax implications are. Do you want to give us, we can all, I mean, it's probably too early for alcohol. It's but I just, it's pretty shocking. The numbers are pretty shocking. And I just learned of a new one besides the federal tax. So, hold on to your hats, people, and
buckle up.
Yeah, exactly.
So, yes, I mean, any gratuitous transfer of property is subject to a transfer tax. And there are 3 different kinds of transfer taxes. There's a gift tax that applies to transfers of property during life. There's an estate tax that applies to transfers of property at death. And then there's something called the generation skipping transfer tax, or the people in the know call it the GST tax. And that's a tax on the transfer of property to 2 or more generations below the transferor. So you're talking about grandchildren and more remote descendants. And, the gift tax and the estate tax, they're mutually exclusive. The GST tax, however, will apply in addition to a gift tax or an estate tax, whichever is applicable. There are a number of exceptions to these 3 transfer taxes. The first is the marital deduction. So there's an unlimited deduction from estate and gift tax for transfers to a U.S. citizen spouse. There's an unlimited deduction for any assets you leave to charity, either during life or at death. And then everybody has an exemption amount from the gift and estate tax and from the GST tax. And right now, that's $13.61 million. So a husband and wife together can leave about $27 million of assets without being subject to any federal estate tax. Now, as you said before, Leslie, there is also a state estate tax in some states. New York is one of those states. The tax climbs up to 16%. And so the way the math works out, it's a combined federal and state estate tax rate of about 50% on assets you leave in excess of that $27 million exemption amount. Let me just go back to, because that's not exactly right. The state, so New York State estate tax exemption amount is not $13.61 million right now. Right now, it's just south of $7 million. So there could be a scenario where somebody is not going to pay federal estate tax because their estate is under that $27 million, but they are in excess of the New York State exemption amount, so they might pay that 16% on some amount.
Which is why, people are moving to Florida and Texas and Wyoming
right.
and all these other places. So if their estate exceeds those amounts and they didn't go to you or to Jillian and have some thoughtful planning in place to sort of either protect assets in a trust or to pass assets along before they die, what would the percentage be of tax on their estate tax, federal estate tax?
Yeah.
Is it 20% or what is the number?
It's 40%. It's a graduated schedule, but it gets up to 40% fairly quickly. So you're going to have some angry beneficiaries if their parents didn't go and do some estate planning with.
Oh my God,
with me
it's
and Jillian.
incredible. So, and that can change, this exemption, right? I've heard this is sort of part talking about the presidential election coming up, right? Isn't this subject to change, as Biden said? Jillian, do you know sort of the word on the street around that, or what
well,
candidate?
I am not in the business of predicting what might happen with this law, because if the past decade has shown us anything, it's that we really don't know what's to come. When I first started practicing, the estate tax exemption was $1 million. And now, as David said, it's $13.6 million. So it's gone up tremendously. And over the course of the past 12 years, there have been numerous instances in which we thought that exemption might go away or go down significantly, and it hasn't happened. But that being said, the present law, so if Congress does nothing in 2026, the exemption amount is scheduled to be reduced by about 1/2. So it'll be approximately $7 million per person, or $14 million for a married couple. Now, who knows, as I said, what might happen. Congress could step in to extend the current levels. They could do something else, or they could just let it, my thought is it's hard to get anything done. So it's likely that it in fact will go down as scheduled. And so there's this opportunity right now for individuals who are in a position to be giving away significant assets to be using that full exemption now while they have it, before it goes down to $7 million.
So how would you advise clients to start doing that if they're in that window?
So basically, you take that full exemption amount, so $13.6 million or $27 million if that's an option, and you put it into a trust for your children. So you use that full gift tax exemption that's available to you. And so when it goes down, if it's then $7 million by the time you die, you've already gotten the benefit of that full $13.5 million. And so what that trust could look like is kind of up to the client, but typically we make these trusts very flexible. They can provide any benefits for your children for their whole lives. They could be available eventually for your grandchildren. We could kind of talk about what these trusts look like, but that's the general idea, is kind of pre-funding what they would get on your death by giving it away now to a trust for their benefit.
You mentioned the GST. I'm using the acronym now, the GST, which is generational skip.
Generation skipping tax. So
Skipping tax.
So in my example, if you gave away $13.5 million to a trust for your children, and you did not allocate your GST exemption to that trust, when your children die and the money passes to their children, your grandchildren, it would be subject to a 40% GST tax at that time.
I see.
Because essentially the government is trying to get their tax at every generation. So if your children had owned the money outright, it would be in their estate. But because they don't own it and it's in a trust, it becomes subject to this GST tax. But as David mentioned, you have this exemption from GST tax, which happens to be the same number as the exemption from gift tax. So if you set up the trust, you fund it with $13.5 million, and you allocate $13.5 million of GST exemption to the trust becomes what we call GST exempt.
Up to $26 million?
If you're married, up to $27 million. And then when your children die, before it goes to their children, it won't be subject to any tax. And if you live many years between now and the time of your death, by the way, that $27 million might
Be 40.
40 or whatever.
Right,
So
I
all
see.
of that growth after the date of the gift also escapes the tax. And then, of course, during your children's entire lifetime, by the time they die and it passes to their children, the growth can be tremendous, and the tax savings as well.
So we talked about sort of the trust versus a will, and I have read about, for many people, their primary asset or their largest asset is their home, and passing that asset to their children or I guess grandchildren or someone else before they die by putting it into a trust. Is that something that, I guess that would be a revocable trust, or maybe an irrevocable trust? I'm not sure. And I guess for listeners, that means it's one that you can't change or take back, right? The irrevocable.
Right. So, if somebody wanted to make a gift of their house to their children, let's say, while they were alive, we don't see that a lot, frankly, because what they're doing is making a gift. And then if they want to remain in the house, then the asset would be includable in their estate under a section of the Internal Revenue Code, unless they pay rent to the children who would own this house after the gift. So we don't see that.
That's an interesting family dynamic at Christmas.
Exactly.
I mean,
Exactly.
Is that why we do it?
I mean, there are some other reasons to do it that are probably beyond the scope of what we want to get into. But just to go back to something else we were just discussing is when you make a gift of property while you're alive, as opposed to dying, owning the property, and then it passes under your will or your revocable trust to a beneficiary, there's a difference in the income tax impact of that. So if I make a gift of property while I'm alive, the recipient of that gift receives what's called a carryover basis in that asset. So if I had 100 shares of IBM and I paid $1 for each of those shares, you will receive those shares with a $100 income tax basis, regardless of the fact that those shares might be worth many, many multiples of that. If instead I had died owning those 100 shares and you received the 100 shares after my death, you would receive a basis in those shares that stepped up to the fair market value of those shares at the time of my death. So you're wiping out the built-in capital gains. So that's something you have to remember.
You're wiping out. I thought you were going to say that if you gift it or if it passes to you, let's say in your will or through your revocable trust, the assets of the stock, that you would be taxed for the.
Yeah.
You wouldn't.
You're
be
not
taxed for the
immediately
appreciation?
taxed on either a gift or a bequest under a will. It's not an income tax recognition event, but you have to think about what the basis in the recipient will be. And that is different whether you make a lifetime gift or you die owning property. Still, it usually or sometimes makes sense to make gifts of property because, as Jillian said, you are saving the estate tax on the appreciation of that asset from the time you make the gift until the date of death. And that could be a tremendous amount of appreciation. And as we said, the estate tax rate can be 40% or 50% if you're a New Yorker. And so saving that estate tax can be a lot more valuable than saving or getting the benefit of a stepped up basis in property. So these are just some of the considerations that Jillian and I go through when a client comes to us and we talk to them about estate planning and potentially doing lifetime transfer tax planning. We have to look at the basis of the assets. We have to think about how they're going to use the assets. In your example, if it's a house, we're going to have to think that through too. So it's a fun sort of puzzle we have to
It is a
put
really
together.
fun puzzle. And then the other piece of it for people who have children that are minors, right? You probably talk to them about them designating guardians. And what is your kind of thought or advice around that when you're talking to clients?
Sure. So this is something that I think they're very concerned with, understandably. Some families have a lot of options. Some families have few options. I think, the most important thing is picking someone who knows your children and knows your values and your family and your lifestyle and understands how you'd want your children to be raised. Something that's important to think about is where they would live. So to your point about the home, if you have young children, sometimes the thought is that the guardians would move into your home and continue to raise your children there, and they would continue going to the same schools, et cetera. If you designate someone who lives in a different state and they have their own children, maybe your children would have to move there, which may or may not be desirable. The most common individuals who people pick, I'd say, for guardians are siblings or parents if they're young enough and capable. Sometimes people pick friends who live in a similar community so they kind of understand the lifestyle that their children are being raised in. Something to note is that the guardian designation in your will is actually kind of a suggestion to the court, and it's technically not legally binding. So everything else in your will is legally binding, but the guardian designation, the court has authority to select whoever the court thinks is in the best interest of your child. Now, clearly, the person selected by the parent, that's indicative of who the best, would be in the best interest, but technically the court could say, for instance, if it required your children to move to another state and they think that would not be in the best interest of your child, that they would pick someone else.
Well, you could have a situation where someone, let's say both, obviously this is a case where both parents are deceased, they designate someone as the guardian, and then let's say the grandparents say, or maybe they designated that person as the guardian 10 years before, and then in that interim, they married someone terrible, or they moved away, or whatever the circumstances are. Maybe today, looking at it again, they wouldn't be the best person to be the child's guardian. That could be an instance, right, where someone contests that assignment,
Exactly.
and then there would be some sort of a hearing, I guess.
Exactly. And the court would have authority to look at all the facts and circumstances and say, what's in the child's best interest here? Would it be the person named in the will from 10 years ago, or the grandparents?
You brought up sort of the process and the time frame for a will going into probate and how long that takes. With your guardians, with your assigned guardians, does that just take effect immediately until this hearing takes place, or how does it work practically?
Practically, in the 20 years I've been practicing, I've only seen this happen once, and it was a matter that, where it happened before I started working on the matter. So, realistically, what has to happen is two parents typically have to die while they have a minor child. So
Right.
Rarely happens, but yeah, obviously the court is going to need to jump in right away. Hopefully there's some family, who can step in. And so there's probably an informal guardian, in other words, somebody who's not actually appointed by the court initially, who's going to care for the children. But again, this fortunately happens so infrequently that, it's something I think.
I like to give the really, sort of outlandish worst case scenario.
Yeah.
No, but it's something that hangs people up a lot.
Right.
I'm very
yeah.
concerned about this, and oftentimes people don't. It kind of holds up the execution of documents because they've decided everything else, but they can't decide this one thing. So,
Well, even in my own person, I have friends who say, "Oh gosh, now I have to change that because they're divorced now," or whatever. Things change.
These
And
are
so,
living and breathing documents.
Yeah.
We as a general practice reach out to our clients every 3 years and say, hey, these are the terms of your documents. Do they still meet with your wishes? Because you might name a parent as a guardian when you're younger, and then they age out. They're 80 plus years old. Doesn't make sense anymore. So these documents, the terms of the documents do change over time, and we certainly encourage clients to look at them every couple years.
So many of us have blended families, or our extended families are kind of blended families, where you have a parent and maybe there's a step parent or step siblings, and let's say your parent who's married to someone who's not your other parent, so now you have a step parent of some kind, they'll leave, for their estate planning purposes, leave their estate to their spouse for the life of that spouse, and then the property is to be passed on, in some cases, to the children of the person who died. And I've seen through examples through friends and things of the stepmother or the stepfather having control of the asset, whether it's the family home or some trust that, they have a life estate, I guess, maybe in the family home, where they live there until they die and then it passes on. And during that course of that time, a lot of things can happen, right? They can decide not to take care of the house. In some cases, I've, heard stories of, they went all these extravagant trips and spent all the money. So how do you advise your clients if they're in a blended family dynamic, if the final intention is for the assets to go to their children and grandchildren, but you want to take care of your spouse who's not biological family to that family? What's the guidance there?
A trust.
Talk about a hot button issue.
there's no magic solution here.
But we do. We see blended families all the time, and typically, the structure we'll discuss with clients and that they'll often choose is that the second spouse will receive the property in a trust, a marital trust, and they will automatically, in order to receive the marital deduction from the estate tax, have to receive all of the income from that trust every year. And the trustee of that trust will likely have the discretion to make additional distributions if they're warranted. But because you have trustees who are sort of, managing the assets, managing the distributions, you can sort of, hope that the trust is going to remain relatively intact so that on the death of that surviving spouse, the property at that point, whatever's left in the trust, can be divided among, the children from the first marriage, children from the second marriage. The other thing we'll see sometimes is if somebody marries a second spouse who's sort of close in age to their children from the first marriage, which we see.
It does happen, yeah.
Right. Sometimes a client will say, well, I don't want the children of my first marriage to have to wait until the death of my second spouse, who's a lot, younger than my first spouse was. So I might make a bequest on my death, both to the children from my first marriage and to my surviving spouse. And so the children from the first marriage don't have to wait until their stepmom dies or stepfather dies.
Okay. And the tax implications of that, because if that person gives their assets to their children and their spouse, the spouse is not taxed, right? If it goes into this sort of marital trust, or just it isn't because it isn't legally taxed, right? They don't get taxed up into the exemption, right?
That's correct. So you do have to think about that dynamic, because any bequests that you make to children don't benefit from this unlimited marital deduction from the estate tax. So all of this needs to be factored in. We use Excel a lot. There's a lot of rough justice around how this plays out. And frankly,
right.
It's these blended families that present some of the more complicated challenges, right?
Well, I would think, just in hearing how you describe, the trustee of that marital trust is a really important role, right? Because if the trustee of the marital trust is someone who perhaps it doesn't have the same goal in mind necessarily of preserving the corpus for the children or grandchildren of the decedent, but more, let's say, is the child of the step-parent, right? I'm just throwing out this actually happened to a friend. So I'm throwing that as and then that person is sort of really in charge of how those assets are spent until the children get them. And is there any governor on that where you can say in a document, Jillian, like as part of the marital trust, that the marital trust you can only have a certain 10% of the assets distributed every year or something like that? Or is there
there's
a rule of thumb?
A lot of parameters you could put on. You can make the trust extremely flexible or extremely unflexible. There are certain requirements you have to have to qualify for the marital deduction. Like David mentioned, the trust has to require that all income go to the spouse every year. You actually don't need to allow distributions of principal at all if you don't want. So the spouse could only get the income and have no access to the principal. That's very restrictive. Conversely, you could allow distributions of principal in unlimited amounts if you wanted to be very flexible. Selecting the trustee is incredibly important. You mentioned the scenario of being too permissive with the surviving spouse. You could also have a scenario where maybe one of the children from the first marriage is a trustee and they're too restrictive with the surviving spouse. So, in this case, oftentimes maybe some sort of more independent person would be appropriate. You could also make the surviving spouse a co-trustee, and you could give them the power to remove and replace their co-trustee. That obviously gives them a lot more power over the trust.
Right.
So it's all a balance of, kind of who you want to have the power at the end of the day of controlling the decisions. So, in general, a lot of our clients like flexibility, and they like to give their spouse a lot of power over the trust to make them feel like it's their money and they have access to it. But the blended family scenario is one in which people tend to incorporate some more restrictions.
Some more restrictions on it. And do you recommend, I think the answer might be no, but in many cases, is the executor the same as the trustee of the marital trust?
So oftentimes, if the executor is the spouse, then you would have the marital trust.
I see.
You would have the spouse as a trustee plus someone. Or you could have both of those people as executors. Oftentimes, there's only so many people that an individual has who they feel comfortable with in trusting these types of financial decisions. So you do see similar individuals named in the executor role, in the trustee role for the spouse, also eventually trustees for the kids. there's typically a lot of overlap, but particularly with the person who's going to be managing the spouse's assets for the spouse's entire life, you want to make sure that the spouse feels comfortable with that person because that's who's going to be controlling their financial, decisions. So you want someone who they can go to and say, hey, I need money for this or that, and feel like they can have an open, honest conversation.
So one of the other ways, right, to distribute wealth might be, and this might be the only reason why one would have it, but life insurance. Can you talk about how that plays into estate planning? Is that another tool to give money to your spouse and children? And is there any rule of thumb about what amount is appropriate depending on the size of the estate? David, do you want to try this one?
We could probably have a whole separate podcast on life insurance. But, when we're talking to clients about it, the first thing we usually talk about is what is the purpose of the insurance? So is it income replacement? Is it a scenario where you have people who are still in their income accumulation phase of their life? And if, mom dies and she was the breadwinner, do we need to replace her income or vice versa? So, with our younger clients, that's usually the primary concern is income replacement. For some of our older clients who have larger estates, or for our younger clients who have larger estates where they're going to have an estate tax bill and their estate may be very illiquid, let's say they're a private equity fund manager or they've got a lot of real estate and they need access to liquidity in short order after their death because, by the way, the estate tax is due 9 months after your date of death, then life insurance can serve a pretty good role for coming up with a lot of liquidity quickly. The other thing we think about a lot with respect to life insurance is how is it going to be owned? If life insurance is owned in a life insurance trust, in other words, the trust is both the owner and the beneficiary of the policy, then the death benefit is not includable in the decedent's estate for estate tax purposes. Whereas if an individual owned a life insurance policy in their individual name, that death benefit would constitute part of their taxable estate. So we do a lot of structuring of the ownership of life insurance policies. And for all of your listeners, before you buy life insurance, talk to a trust and estate lawyer to talk about how it should be owned, because the tax consequences, depending on the size of somebody's estate, can be dramatic.
That's interesting. So with the life insurance trust, that is not taxable if it's put into a trust, and then just the income from that policy payout, whatever that number is, that then becomes taxable? Or
if it stays in the life insurance trust, to the extent it stays in the life insurance trust, even then it's not taxable. There's income tax on it, but
right, okay, but
as long as it is outside of somebody's estate, there's no estate tax on it. The grantor of the trust, the decedent can't retain, the technical term is any incidence of ownership over the policy. But if you have a trust that somebody sets up, they fund it with a life insurance policy. They make gifts to the trust each year that enable that trust to pay the premiums on that policy.
I see. Okay.
Then it won't be part of their taxable estate.
And is there any sort of cap on how large that a life insurance trust would be?
It's funny. The cap is really the carriers and how much insurance they're willing to sell.
Right, I see. Yeah.
And the reality is, it gets so expensive that you're not going to want to buy tons and tons of it. And it also depends on what kind of insurance, what kind of life insurance you're talking about. And that's, again, could be the subject of another podcast. But there's, term insurance, which is very inexpensive and just covers if you died during the term. But if you outlive that term, the life insurance goes away. And then there's, very broadly speaking, there's permanent life insurance or whole life insurance, which can stay in place for somebody's entire life, assuming they continue to make the payments. And
that's often much more expensive, obviously,
Correct.
whole life, because you're going to have to, so that's definitely going to be paid out at some point. Now, you mentioned for people that are growing their assets, they're younger clients of yours, that the life insurance policy might play a role as being income replacement. I would think that clients should start thinking about not just their moneyed spouse or the spouse that's working outside the home, but having perhaps a life insurance policy for the spouse that's not working outside the home, because you'd have to replace that work.
Yes.
Right? With hiring people to
Yes.
to do those
Or maybe the
those
moneyed
roles.
spouse. Maybe the moneyed spouse says, you know what, my spouse died. I want to spend more time with their kids. With my kids, I want to take a step back from work. But you're absolutely right. I think people are wise to consider life insurance on both spouses, moneyed and non-moneyed.
And is there any kind of best practice or rule of thumb for an amount, or it's just really dependent on someone's personal circumstance?
You could talk to life insurance agents who will probably differ. I've heard 10 times income is a reasonable number, but we usually defer to the life insurance agents. We're happy to serve as guides, and they can bounce ideas off us, but we'll sort of defer to the clients and their thoughts on that.
So you talked about when someone comes in, right, and you give them kind of the overview. Are there other kind of things that people should be thinking about? One thing I've heard is just making sure that all of your accounts, it could be your Con Ed bill or it could be your brokerage account, have both of your names on it, or you've given your spouse permission, right? So Jillian, do you talk about that when clients come in and give them any guidance on
Yeah, well, certainly
that?
This is one of the reasons that we talk about funding a revocable trust while you're alive. So as we were talking about in the beginning, if you transfer assets to your revocable trust while you're alive, you have that immediate trustee succession that occurs if you become incapacitated or if you die. So the successor trustee can step in right away and they have authority. Whereas if it was subject to probate, you'd have to be in that delay and wait for the court appointment. In terms of the types of accounts you were talking about, I think, having a list just of all of these accounts and all of your assets and where they are and account numbers and that kind of thing.
And passwords, things like that?
Yeah, passwords is a whole other difficult situation as well. But the more information that your spouse and your children, whoever it is after you die has about what you had, the easier it'll be for them. Because a lot of the time and energy is spent just figuring out what there was. And that can be
like that old
really hard
department store credit card that you didn't know that they still owed money on. And so that's interesting. So a list of all of the accounts, all the passwords, all that sort of thing. And then you need to give it to someone, to keep it, which could be your attorney, I guess, or your surviving spouse or your assistant or whomever you trust.
We're happy to hold on to whatever clients need to be safely kept. But oftentimes I think they keep this at home somewhere, or, you could have it in a safe deposit box or something. But I have a lot of clients who are quite responsible and they keep detailed balance sheets and they update it every so often, and it's kept on some sort of spreadsheet or whatever it is, and the spouse knows where it is. And, eventually your children should start to get some of this information. This is kind of a whole other subject, but like, when is it appropriate to kind of start educating your children about finances and all of the things
when
that
do
come
you
with
have
that.
those conversations?
Yeah,
if you have older clients and was there kind of like, you see them every 3 years, you're like, Jimmy's looking pretty old. I think we need to have the talk with him that it's time, or,
It's not even about being old. It's also about helping your children, because giving them, empowering them to understand their finances and give them an education about this stuff earlier, I think is generally speaking better, as long as they're responsible people. But clients are really all over the map on this. I have some clients that, their child's 21 and they're like, let's tell them about everything. And then other clients whose kids are in their 40s and they've really kept them shielded from all the information, all the details about what kind of their financial situation looks like. And this, I think, is a disservice really for the children, because when the parents die, which will happen, if the children are not equipped to understand what the assets are and what the expectations are and all the things that come with managing money, it could be really overwhelming to them. And people are all coming around them. They don't know who to trust, and they might make poor decisions. And if you had given them the guidance and education,
and be able to ask them questions, right? It's an opportunity to ask questions.
And it's not an all or nothing thing. It's not like one day you sit down and say, here's everything about everything. You start young. You might, a lot of our clients were involved in this process, and we sit down, maybe the kids are 25, 30, whatever the age is, we start explaining, this is what a trust is. This is, the expectations in our family are about money and work and philanthropy and whatever the things are. And then, maybe when they're older, they start seeing more numbers and that kind of thing. But I think this process of education is really important to spend some time thinking about.
So many of your clients are higher net worth individuals. And I know, or I think that I know that one tool, and it's also because people have, a desire to give their assets and wealth to charity. You might advise or help guide them in the creation of a foundation or a family foundation. Under what circumstances, David, do you make that recommendation? Do people come to you asking about that? And can you talk a little bit about how you kind of guide and advise on that?
Yeah, I mean, it's something more often clients will approach us about. But I have certainly had scenarios where, people are hemming and hawing about, oh, should I leave everything to my kids? Or, and the question is, do you have a charitable intent? And, it's great that many of our clients do. And the question is, what do you do with that? And a private foundation is certainly an option. Because there are state filings, there are federal filings that go along with this. You need to have an annual meeting. There is some administrative cost associated with a private foundation, which usually means we're not recommending private foundations for clients unless we're talking about a foundation that's going to be, let's say, in excess of $25 million. Otherwise, the administrative time and expense just doesn't make it worth it. And for clients who might want to, have some structure around their charitable giving, we'll often recommend looking at what's called a donor advised fund or a DAF. And these are administered by Fidelity, Vanguard, Schwab. There are all sorts of administrators of donor advised funds, but essentially they will take on all of the administrative work around what you'd commonly associate with a private foundation. So we've seen, the growth of donor advised funds were used by our clients a lot, probably in the past 15 years or so.
And with that, do you advise people, are they circumstances where clients have more liquid assets, or let's say you have a client that has a very large real estate portfolio, let's say, but it's not liquid, or stocks, but they haven't, I guess, so if stocks need to vest, would they, I don't know, that's maybe a different conversation. That just occurred to me too. Would those be clients that you wouldn't necessarily want to suggest a family foundation, or is it really, it's not?
There's really nobody for who it's entirely inappropriate.
Okay.
You do think about what sort of assets you're going to give either to your donor advised fund or to a private foundation. A lot of clients will give appreciated securities because you will typically get a deduction for the fair market value of those securities, even though your basis might be very low. So you're eliminating that capital gains tax. So there's a lot of, tax advantage gifting that our clients do and that we talk through with them. And we actually have, Jillian and I have a partner who heads our exempt organizations practice. And, this is pretty much all she does, advising clients on private foundations, public charities. So it's really a whole specialty unto itself.
And what about families that create kind of family offices? Is that sort of their way of kind of pooling their assets and then deploying them in different investments? Is there any kind of a floor and an amount that you would recommend for that? Or what kind of circumstances do you advise that is a good thought for a family, either in their estate planning or next steps to their children after the fact?
Right. Family offices mean different things to different people.
Right.
And, for some people, they've got a person who they hire who just, sort of a bookkeeper and makes sure bills get paid. And you could view that as a family office. There's somebody who's, sort of the point person on the administrative side of things. For clients who have a lot more money, and if there are lots of trusts involved, lots of family members, if you've got a, multi-generational family and a family could benefit from this kind of a structure, people have a lot more elaborate family offices, which will deal with the investments of the family. They'll deal with the tax planning, trust and estate work. They'll administer, the residences, planes, all sorts of things. And there are tax advantaged ways we can structure that. And it's something we've had a lot of experience with, and it's something that's become more and more popular, over the past 10 years or so, is the family office space.
And do you think that's because is it sort of the idea of when you're pooling your assets together and having it managed as a family by 1 or 2 or 10 or 15 people, that it's kind of a way to create generational wealth? Is that sort of the thinking behind it?
That's definitely part of it. And the other thing too is if you can pool all of these trusts, you've got this huge amount of private capital that you can invest in a way that you probably couldn't if you were
see.
investing smaller sums of money. So you can make, direct investments in private companies. You can get better deals if you're going into a private equity fund or a hedge fund. You might get side letters you wouldn't otherwise get. So there are a lot of advantages to.
What is a side letter? Extra.
A side letter is
This is like
sort
the
of a,
GST.
Yeah.
I'm getting all the.
a special deal, that you might be getting on the investment terms.
Oh, because
because it's a large
because of the
investment,
size.
let's say.
Okay.
Right.
All right. So I want to ask you both, but Jillian, I'll start with you. Are there any kind of do's and don'ts, biggest mistakes that you see when people are planning their estate?
So something that I kind of touched on earlier is kind of holding up signing of documents because of certain decisions, such as a guardian, or often the remote contingency provision, which is like what happens if, God forbid, everyone in your family, immediate family, died on a plane together. Where would the money go? That really holds people up and prevents them from signing documents for like
And you're like,
months.
well, you won't even be here. It doesn't
the odds of that happening are extremely low. These documents can be changed anytime. So like my advice is just sign something. Something is better than nothing. And then you can always update it as your thinking evolves, but it's better to have something in place. I think you opened our conversation with this isn't a fun topic for a lot of people. And so that also kind of can prevent people just like even
thinking
the act
about
of
it.
signing things just like it forces them mentally to confront this issue, and it's uncomfortable. But if you have draft documents out there, they're not effective. So like if you die and you think, oh, but I had a draft and they'll know what I wanted. It's like, no, if it's not signed, it's not a valid document. So you really need to like just come in and sign. And I really frequently see people dragging their feet. So
I have a friend, a very close friend, who told me that they had sort of changed she and her husband had discussed it, changed who their guardian was going to be, but they haven't gone back to see their lawyer, and they just wrote it in on their will. And I say, that is not going to hold up. You've got to, so that might be another, on the big mistake front. David, what about you?
Yeah, I think Jillian's was probably my number one as well. The other thing I would say is to revisit the documents. Don't just put them in a drawer and forget about them. Your life situation will change. The fiduciaries you named in your documents, guardians, trustees, executors, they're going to, the desired people are going to change. So take a look at them every once in a while. And, we have, Jillian and I have a partner who says that estate planning is a great act of love for your descendants and your spouse. And I think that's a great point. You got to think about, what are you leaving your children and surviving spouse with? Is it going to be a mess, or is it going to be something that you've put in place thoughtfully? So, pay attention to it.
Yeah, and don't just think that, they'll be able to figure that out and handle it, but really try to do some of that thinking for them beforehand.
Right.
When do you advise people to start thinking about estate planning? Is there a certain age or is it when you get married, when you start, having significant assets?
I think it's more life circumstance than an age, but usually having children is what prompts people to think about it. And that is probably, if you have children, you really should have documents in place, because if you don't have a will and a revocable trust, state law says what happens to your assets when you die, and oftentimes that's not really the same as what you would want. And then even if you're not married or you don't have children, once your assets are substantial, you should also have a plan in place, because, again, if you don't, state law will dictate where your assets go, and especially with substantial wealth, I think, you've spent so much time earning that money, you probably want to give a little time and thought to what happens to it when you're gone.
Oh, for sure. And then just for listeners, if you don't have a will and you die, it automatically goes, if I recall, if you're married, I guess, to your spouse.
Well, this is state law
right.
specific.
So
in
like,
New York,
I see.
actually,
Yes.
1/2 goes to your spouse and 1/2 goes to your children. And that is actually not what most people would want.
Right.
Even if your children are, babies, they'll inherit all this money, and most people want their spouse to get everything, and especially if their children are minors, so the spouse can kind of use that money to take care of their family. But at least in New York, that's not the default. So if that's what you want, you need to have a document that says that.
And if you're not married and you don't have children, it goes to your parents?
Parents, then if you don't have parents, siblings. And then nieces and nephews. But again, each state,
each state has different laws. Well, thank you both so much for coming. I really appreciate you taking the time. I learned so much. I know I have not revisited my documents in some time. I need to.
There you go.
I'm definitely on that 3-year schedule, but this has been so incredibly helpful, and I really, really appreciate you both being here. So thank you so much.
Thanks for having us.
Thank you. Our pleasure.
That brings us to the end of this episode of The Interview. A huge thank you again to Jillian Merns and David Posner for joining us. And as always, thank you again for listening. If you enjoy the show, please rate and review us on Apple Podcasts and follow us on Instagram at The Interview with Leslie. A new podcast is released every Wednesday. Until then, this is Leslie Heaney, and don't forget to join The Interview.